An Indian national named Kulbhushan Jadhav was arrested in Pakistan and charged with terrorism offences. 3 weeks later, when Pakistan finally notified India of his arrest, the Indian government applied for consular access to Mr. Jadhav. Consular access is guaranteed under Article 36 of the Vienna Convention on Consular Relations, an international convention which had been signed by both India and Pakistan. Under that provision, when a person is arrested in another country, the arresting country must alert the prisoner's country and then facilitate access to that prisoner by consular staff. India repeatedly requested consular access. Pakistan ignored them. Nearly a year after the arrest, Pakistan wrote to India asking for help with the investigation into Mr. Jadhav, stating that India's consular access to Mr. Jadhav would depend on whether they assisted. Restricting consular access in this way was improper and dishonourable. To make matters worse, in April 2017, a military court in Pakistan tried Mr. Jadhav, convicted him, allegedly on the basis of confessions, and sentenced him to death. So he had been arrested, held for over a year, had confessions extracted from him, and then was sentenced to death, all without being allowed consular access. India sued Pakistan for its breach of the Vienna Treaty on Consular Affairs. However, there was every chance that Mr. Jadhav would be executed before the International Court of Justice got around to handing down a decision. So India went to the court seeking an interim ruling, or what are called in the International Court, provisional measures. The order they sought was fairly simple: for Pakistan not to execute Jadhav prior to a decision being handed down. The court noted that the power of the court to indicate provisional measures will be exercised only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights in dispute before the court gives its final decision. The mere fact that Mr. Jadhav is under such a sentence and might therefore be executed is sufficient to demonstrate the existence of such a risk. From this case, we confirm two things: that a nation which is denied consular access to an individual may sue to obtain that access, and that provisional measures will only be granted if there is a real and imminent risk of irreparable prejudice if the provisional measures are not granted.